I rarely represent in the military courts, but I sometimes do. And at the moment, I represent in two petitions that are pending in the Supreme Court regarding procedural issues or fair trial rights in the military courts in the occupied Palestinian territories. But I can say that these petitions were a result of the research that I'm going to speak about today, and not the other way around. So this is just to open the floor. The idea of what I'm going to speak about today came to me a few years ago when I started to meet Palestinian colleagues, Palestinian lawyers who represent defendants in the military courts. And I started to wonder, how is it to be a lawyer representing defendants in such a court, in a court where you face the occupation army? And I started to know these courts, and one of the most striking facts about the courts and about the defense work in these courts were, and still is, the frustration and the distress of the lawyers who are working in these courts and feel that they hardly stand a chance and hardly have a proper legal work to do. And I was not the only one to get this impression. When I started to read and to learn about these courts, I found that other researchers, sociologists, anthropologists who wrote about the military courts in the occupied Palestinian territories noticed the same thing. And I can just quote from one research saying that most lawyers feel that the military court system is so skewed against defendants as to leave virtually no scope for lawyerly action. Prominent West Bank attorney Jonathan Kutab is quoted here saying, "Many top West Bank lawyers refuse to practice before the military court. I hate myself and question my integrity as a lawyer when I appear in the military court. I tell myself that I'm a social worker and not a lawyer, bringing cigarettes to my clients." So the basic feeling is that besides bringing cigarettes to your clients, there's not much you can do. Another quote by a lawyer saying that the lawyer's role is limited in most cases to begging for mercy in a merciless environment. And learning some more about the military court system, I became acquainted with the trend of applying Israeli law in these courts into the military law that applies to these courts. And I read an article by the vice president of the court, Yaël Ronen, who's not here today, describing a very progressive narrative of the law in these courts, of how human rights standards are improved through the application of Israeli law. And if I had read this article without knowing what is happening in the courts, I would think everything is perfect. But knowing what is happening in the court, I asked myself, if everything is so good, how come everything is so bad? And in Palestinian eyes. So this was the starting point for this research. Now, there are many reasons for this thing, and I won't go into all of them. It's too much. But I will concentrate on the point of the application of Israeli law in the military courts and in the military law that is applicable. And I understand that Mr. Mishnayot is going to discuss that later on. So we will able to see that from another point of view. But the application of Israeli law to the military courts and to the military law is used to demonstrate or to argue that it improves human rights standards in these courts, since Israeli law is better than military law, and then we apply more progressive standards that are more appropriate to for fair trial rights and human rights in these courts. So what I want to see is that so? Is it really the case? Is application of Israeli law really promotes human rights in the military courts? Now, I will look at that from the perspective of IHL, International Humanitarian Laws, and the law of occupation, and from human rights perspective, international humanitarian law generally prohibits unnecessary changes to the local law, and in particular, application of the occupier's law. However, application of Israeli law into the military legal system is by now a growing trend, and I don't argue that it doesn't comply better with human rights standards. The question is rather whether the road to improve human rights standards in the military courts indeed passes through Israeli law and not other ways. But first, I want to lay some bases, and since I'm the first speaker today, to introduce the military legal system in the occupied Palestinian territories so we know what we're talking about, and then we can move on. I'll try to make that as short as possible, but it's not very short, so only the basic and necessary things. I will describe the system and then the application of Israeli law and then the criticism that I have about it. So I just want to start with two general notes. First of all, I'm not discussing the legitimacy of the system as a whole. I assume that legal system of an occupation will never be legitimate in the eyes of the occupied people. It's not a democratic legal system. They have no way of participating in lawmaking. They're not represented in the legislative bodies. So it's not the question of legitimacy. But we can discuss, and we should discuss, the observation of fair trial rights in such a system, even if it does not enjoy this kind of legitimacy. And the other point is that I'm not dealing with other areas in which Israel does apply its own laws to the occupied territories. There are other areas of law, I won't touch on them, but only in the criminal law that is practiced in the military courts. So the legal construction of the Israeli military system in the occupied territories started in 1967, really on the first days of the occupation, and it was basically structured on in line of the demands of the Fourth Geneva Convention and of international humanitarian law. Within days, a system of military legislative proclamations and orders were signed by the military commander of the region, and they were published. And military courts were established to enforce those legal orders and proclamations. The system did not change significantly since then, although many changes occurred generally, politically, that have importance in international law. For instance, the establishment of the Palestinian Authority, the enactment of the Palestinian Legislative Council. All this did not penetrate the Israeli military legal system. According to Article 64 of the Fourth Geneva Convention, the penal laws of the occupied territory shall remain in force, with the exception that they may be repealed or suspended by the occupying power in cases where they constitute a threat to its security or an obstacle to the application of the present convention. So the principle is that the local laws should remain in force, and proclamation number 2 of the Israeli military followed that line and stated that the law that existed in 7th June 1967 will remain in effect to the extent that it does not contain any contradiction to the proclamation and orders of the army. And with revisions ensuing from the establishment of the Israeli Defense Forces regimes in the region. Proclamation number 3, we're all talking about 7th June 1967, established military court and established their jurisdiction to adjudicate offenses against these military orders, and as an annex to that proclamation was the basic criminal law of the military system. That's called the Security Provisions Order. I will say SPO to keep it short. And this order is a whole criminal law. It includes criminal offenses and criminal procedure and everything that's necessary to a criminal legal system. And it actually replaced, for this system, for the military system, the criminal laws that existed under the Jordanian rule. The usual courts, the courts that operated, continued to operate. The then Jordanian courts continued to operate, but the military system took an exclusive jurisdiction to adjudicate offenses in cases of security offenses against Israel. So the SPO, the Security Provisions Order, was a totally original Israeli piece of legislation that was introduced. It was amended many, many times since, I think 140 times or even more than that. And it is and other orders were published with a criminal effect, with many, many aspects of criminal justice system, like rules for the responsibility for offense or juvenile offenders or other aspects. And by now we have the Security Provisions Order is as long as about 335 articles, many, many sub-articles. So it's a huge corpus of legislation with many, many amendments on the way that is in fact practiced in the military courts. So this is as far as legislation goes. Now, to describe the operation of the courts, the judges and the prosecutors are all military personnel. They're from the IDF, and they are all trained as lawyers, as jurists. Defense in the military courts is done either by Palestinian lawyers or by Israeli lawyers. And actually, it's the only forum where Israeli lawyers from the Israeli bar and Palestinian lawyers from the now Palestinian bar, in the past it was the Jordanian bar, are able to practice, both of them. But of course, they differ very much from one another because the legal education of Palestinian lawyers is not Israeli law. They study in law schools either in the occupied territories or in other Arab countries or other countries, Eastern European in the past. And generally speaking, their legal education is an education based on the civil law system. The system in most Arab countries, including Jordan, although there was a British mandate, is a civil law system. And they learn, if they learn in the territories, they learn Palestinian law, which is now, which exists now because of the Palestinian Legislative Council, and Jordanian law, which remained in practice or in force, some of it in the occupied territories. They have no opportunity to study Israeli law in their, as part of their legal education. So you see a court where the division between prosecution and defense is not only a division of their professional roles, but a division between the occupier and the occupied, different languages, different education, different legal cultures between the prosecution and the defense. And if to get into the language of the courts and the language of the legislation is published in Hebrew and in Arabic. There is a formal Arabic version of the legislation, although it's hard to get to, but it exists. On the other hand, in the courts themselves, the language is Hebrew. There is an oral interpreter in the court hall that interprets what is being orally said, but the indictments, the protocols, the decisions of the court are not translated into Arabic. So if a Palestinian lawyer practices in these courts and he does not read Hebrew, he can't read the decision of the court. He would have to use some help in order to read this decision. Generally speaking, he or she can choose to argue in Arabic. There would be an interpreter, but texts are not translated into Arabic. And so you'll see later, and you can already see that this is a kind of a problem. Now, in terms of jurisdiction, I'll make it short. The Israeli legal system and the military legal system in the occupied Palestinian territories actually have concurrent jurisdiction over security offenses that are committed either in the territories or in Israel. So extraterritorial clauses in both systems enable both systems to adjudicate offenses against security by Palestinians or by Israelis that are committed in Israel or in the occupied Palestinian territories. So it's actually a matter of policy that since the 80s, only Palestinians are charged in the military courts and mostly Israelis are charged in the civil courts in Israel. So if even two persons are parties to the same offense, one is Palestinian and the other one is not Palestinian, he could be a resident of East Jerusalem or an Israeli citizen or a tourist, the Palestinian will be charged in the military court and the Israeli or the other national will be judged in the civil Israeli court. And it's not only a matter of the location of the trial, of course, it's a matter of a whole different law that would apply for each one of them. So these are, and there are cases that Palestinians are charged in Israeli courts. For instance, Marwan Barghouti, who was a very famous leader of Palestinian resistance, was charged in a civil court in Israel. So the jurisdiction exists, and it's a matter of policy where people are brought to justice. I would like to get into some characteristics of the military law, just to give you a feeling of what it's like. And the characteristics I've come with are four. One characteristic is that the law is very open-ended and vague as to the definition of offenses, and we've actually seen that even yesterday discussing Chinese law and British law as to incitement and other security-related offenses. It's a general characteristic. We're not very special with that, but still is a very strong characteristic. Just to give you one example, the offense of violations against public order includes any act that harms or interrupts with the security of the region, as well as being member of a group that one or more of its members are violating or violated the public order in such manner. So virtually anything can get into that. And that is quite a challenge for the principle of legality, saying that criminal offenses should be narrowly and strictly defined. Another characteristic is that maximum punishments are very high, and that's relative to the Israeli system and in general. And the Military Court of Appeal acknowledges that for any given offenses, you can see that the punishment in the military law would be higher than under Israeli law, and there are many differences in that respect. Many offenses are punishable by life sentences and very high sentences. Criminal procedures. Criminal procedures include severe and arbitrary violations, at least as I see it, of personal liberty and fair trial rights. For example, the initial time of detention before first judicial review is 8 days, compared to 24 hours in Israel or in Britain or in other places in the world. People can be held incommunicado without access to a lawyer up to 90 days. Arrest before charges could be up to 6 months. So all the time frames are very, very long, and they allow for violation of personal liberty in a way that we don't know in other places. And the last one is that the rules of evidence and procedure are quite indeterminate, and it's another, here again, it's a challenging of the principle of legality. And I will quote, because it's important, the Security Provisions Order, the SPO, says that concerning evidentiary rules, the military court will act in accordance with the obligatory rules in criminal matters in the State of Israel. So actually there are no evidence rules. There's reference to Israeli evidence rules. And concerning procedure, the military court is entitled to order in all matters of trial procedure not determined in this order, trial procedures that appear to it most appropriate for ensuring justice. Again, there's big liberty for the judges to apply procedures if they're not set in the order. And so this was like the system in general. And I'll move now to the application of Israeli law, and looking into the presentation of Mr. Mishnayot, I see there's no doubt, and it's a proclaimed policy that the military courts apply Israeli law when they can, because they see it more appropriate to ensure justice or human rights. But application of Israeli law is not done only in the jurisprudence of the court, it's also done in the legislation, the military legislation. And the example I just gave concerning the rule of evidence is the central example, but also in other ways, when the legislation took Israeli law, it was done differently, not by reference to Israeli law like was done in the evidence, but taking segments of Israeli criminal law and adopting them, copying them into the military orders, which of course makes a difference, because you don't have to turn to Israeli law to see what it is. You have it written in the military order. You know what it is, and you don't have to know Israeli law in order to know that. So besides the legislation, military judges very often apply Israeli law, and in matters of evidence and criminal procedure, it's relatively easy because the law enables that. And in other substantive matters, they also do that, although the law does not provide for that explicitly. So there are decisions of the military Court of Appeals that, although, for instance, the Israeli law of arrests does not apply to the region, we guide ourselves to act according to the principles set in that law. And in other matters where the court found itself unable to apply Israeli law, it expressed its discontent from this situation. And I can quote another decision saying that we are by now tired of repeating that unfortunately these amendments do not apply in the region, and we express our criticism as to this bifurcation of laws. And the court even says that this criticism has led the court to apply in some cases a far-reaching interpretative approach, which by judicial legislation brought to the unification of the law of the region with new provisions of Israeli law. So it's done in many ways, and there are very explicit decisions, and the article I mentioned before of the vice president of the court giving reasons why are we doing that, why are we using Israeli law, and the reasons differentiate. Different judges give different reasons, but some of the reasons given, for example, because it's important to see the rationale behind this. So one reason given is that there's a personal, of course, reason because legislators and judges are Israeli jurists, and this is the law that they know, and this is where they've turned to. But another reason given is a material reason, because some of the orders, the military orders, follow Israeli law, then it's natural to turn also into, or to look at Israeli jurisprudence that applies these laws and to learn from it. Another reason is the concurrent jurisdiction I was discussing. If the same persons doing the same offense can be tried in both systems, there's a concern for discrimination or for equality. It seems just that two people committing the same defense will be judged by similar laws. And a fourth reason given, that is from Justice Gordon, the previous president of the Military Court of Appeal, is the quality of the Israeli legal system. The judges think that the Israeli legal system is a very good one, and they want to apply it. Other reasons given, that is from the article of Benishu, is improving human rights guarantees, civilization, saying that the occupation, it's a prolonged occupation and citizens are being tried by a military court, so we should go through a process of civilization of military law, and creating a unified legal discourse in Israel and in the territories. That's another reason, so that lawyers from both sides, academics from both sides can share the same legal discourse of this system. I won't get into the details of the different amendments, or because there's no, I don't argue that they are not better in the term of law. It's a better criminal law, but the question is rather different. I just want to say very short that there are other aspects of, or the aspects that I discussed before of this system meaning the vague definition of offenses, the harsh punishment, the procedural guarantees, they are not addressed in this application of Israeli law because they are in the law and there's not much to do about it, but judges also don't express their discontent with these characteristics that often. So what is the problem actually? Where is the problem? Better criminal law is better. There's no doubt about it. But its application, its implementation in an occupation legal system is far from obvious. And this trend generates problems both from IHL perspective and from human rights perspective. So the basic understanding of what occupation is that the occupier is not the legitimate sovereign, and it can't apply its own laws to the occupied territory. It's a temporary regime. It's a kind of the occupier is a kind of a trustee of the territory until legitimate sovereignty is reestablished. And the Fourth Geneva Convention actually protects the protected people, the occupied people, from application of the occupier's law, and it's very explicitly says that the penal provision shall remain in force, etc., etc. And if I turn to the commentary on the Fourth Geneva Convention, for instance, it says that the occupation authority cannot abrogate or suspend penal laws for any other reason, and not in particular merely to make it accord to their own legal conceptions. And that is a very important motive. So I'm trying to make it shorter. And in this respect, where IHL forbids actually the occupied from applying its own laws, there's an interesting discussion between scholars while Yoram Dinstein saying that a test to the lawfulness of legislation in an occupied territory is the existence of a same law in the occupier's country. And if the same law exists, it's a sign for sincerity, for similar concern for the occupied population, like the occupier shows for his own population. Now, other scholars do not agree, and I tend to agree with them, pointing that it's another territory, it's another people. Similar concern does not always mean that similar laws has to be applied, and then you have to remember that this is an occupied territory, and there are other tests like the necessity of the legislation and the preservation of the local laws. But I do agree with Dinstein on one point, that it's a good sign for the sincerity of the applying these laws, like when people sincerely want to look after the occupied people the same way where they do in their own country. So one of the central problems of this application is a problem of language. Israeli law is not translated into Arabic and is not part of the legal education of the lawyers. So if we say that we apply the rules of Israeli law, Palestinian lawyers have no way of knowing what that law is and have no way of practicing it. And this goes all along the way with public translation and legal education, the translation of the court decisions, etc. So this barrier of language and legal education actually tempers the realization of this law by Palestinian defense lawyers. And it makes the law into an act of grace of the judges, that they say, this is a great law, I will apply it, but I will decide how to apply it, because you can't challenge the way that I apply it. You don't have a way of knowing this great law that I am applying in these courts. Now, another very important aspect that is brought from human rights law is equality of arms. Equality of arms is an aspect of fair trial rights that mandates that the prosecution and the defense have the same means to litigate the cases. And in applying Israeli law, the Israeli prosecution gets a huge advantage because it's their own law, it's the prosecutor's law, while the defense, it's not their law and they can't apply it the same way. So the equality of arms is badly damaged, is not existing at all, and it's a policy actually that prevents equality of arms from being realized in the military courts. I will end here. I have some more comments, but maybe we'll keep it for the discussion.